Hello and welcome to MediaNama. On January 3rd, 2025, the Indian Ministry of Electronics and Information Technology released the draft DPDP rules to operationalize the Digital Personal Data Protection Act 2023. However, the rules have since sparked significant debate. Here's everything you need to know about the key provisions of the draft rules and what it means for individuals, businesses, and the future of data governance in India. Firstly, with regards to processing children's data, the rules mandate that online platforms must check the ages and identities of individuals identifying as a parent when obtaining verifiable consent for processing of data of users under the ages of 18. This provision comes in addition to the DPDP Act 2023 prohibiting platforms from processing the data of a child or an individual under 18 before obtaining verifiable parental consent. Two methods can be used for this parental verification. The first method is when the parent uses the platform the child wants to create an account on. In this case, parents can ask the platforms to rely on the age and identity information already provided to it. The second method arises when parents don't use the platform, and this allows them to verify their age and identity through other mechanisms. These include identification through a legally authorized entity or a government body, a virtual token mapped to the identity and age details of the parent voluntarily provided by them, or the use of digital locker service provider. While these rules shed lights on how platforms will verify who is a parent, there are several other concerns. Firstly, the question of how the platform will ascertain who is a child and who is a grown up also comes up. To explain, since platforms rely on the assumption that a child declares himself underage or a parent comes forward, children could evade this obligation entirely by inputting false information. Further, since the onus of preventing such a situation falls on the platform, they would have to invariably verify everyone's age, making it impossible for people to use digital services anonymously. Experts have also pointed out other gaps, like the platform being unable to confirm the actual parent child relationships and shared device usage, undermining ID based age gating systems. Another key issue is that the DPDP Act doesn't apply to publicly available data made available voluntarily by the user. MediaNama has also previously pointed out that companies creating AI models can freely scrape such data, including publicly available personal data of children. Further, in terms of behavioral monitoring and tracking of children, the Act prohibits platforms from carrying out such activities unless the central government believes that the processing of such data is done in a verifiably safe manner. However, entities like clinical establishments, allied healthcare professionals, and educational institutions, amongst others, are exempt from processing children's data without parental consent and carrying out monitoring activities. Persons with disabilities are also included in the Act, as in, this Act is also applicable to persons with disabilities for whom it mandates a similar obtainment of verifiable consent from lawful guardians before processing their data. The platforms additionally must certify that the guardian is appointed by a court of law, a designated authority, or a local level committee under the law applicable to guardianship. Next, moving on to the rights of data principals or individuals whose data is being processed, the rules mandate that they can exercise their rights through identifiers provided by data fiduciaries or entities processing personal data. These identifiers include customer IDs, application references, or license numbers. Data fiduciaries and consent managers are also obligated to provide clear instructions on their websites or apps for data principals to make such requests, including required identifiers. The following four rights are enshrined within the rules. First, data principals can access information about their personal data based on the necessary outline processes within the Act, and the request for information may be authenticated by the aforementioned identifiers. In response, the data fiduciaries must provide a summary of the personal data they process, the activities undertaken for processing, and even disclose the identities of all the other entities with whom the user's personal data has been shared. Second, the user can also request the erasure of personal data by contacting the data fiduciary. However, data fiduciaries must themselves erase the personal data if the data principal does not engage with the fiduciary for a specified time, provided that there is no legal obligation requiring the fiduciary to retain the data. However, before such an erasure, the fiduciary must notify the data principals at least 48 hours in advance, informing them of such an erasure unless the data principal takes necessary action. And they should also provide an opportunity for preserving of the data. In case of e-commerce entities, social media platforms, and gaming intermediaries, such organizations can retain personal data up to 3 years from the last interaction of the data principal or up to 3 years from the date from which the rules came into effect, whichever is later. Third, data fiduciaries and consent managers must establish a grievance redressal mechanism and publish the timeframe for addressing grievances. In case of an unresolved issue, individuals may approach the Data Protection Board after exhausting other mechanisms. Fourth, data principals can nominate individuals, like family members, to act on their behalf for data related matters in cases of death or incapacity. Elaborating on the rights of data principals, the draft rules also issue clarifications on consent managers who play a crucial role in the management of personal data. To explain, a consent manager is an entity enabling data principals to give, manage, review, and withdraw consent for the processing of their personal data by data fiduciaries. However, to be accepted as a consent manager, an entity must meet certain criteria, like having a net worth of not less than 2 crore and having an adequate volume of business, capital structure, and earning prospects, among others. The applicability of various candidates will be determined by the Data Protection Board, which should publish the particulars of various registered users on its website. The board has powers to inform consent managers of non-adherence, provide instructions for compliance, and revoke the registration of managers in certain cases. The registered consent manager must fulfill certain obligations as stipulated by the rules. To begin, they should maintain a website or an app serving as the primary interface for management of user consent. Next, they must also maintain records of consent given, denied, or withdrawn, and of personal data sharing with other transferee data fiduciaries for a period of at least 7 years or longer as required by specific laws. Notably, such consent managers should also ensure that in sharing the personal data with data fiduciaries, the content of the same is not readable by him, and they should also take reasonable security safeguards to prevent such personal data breaches that may occur. Finally, while data fiduciaries are not mandated to work with consent managers, they have obligations to prove that they have records about consent given, denied, or withdrawn, which may be managed using consent managers. Speaking at a previous MediaNama conference, industry personnel also explained that while they don't oppose working with consent managers, the same depends on the amount of information that is required to be shared with them. However, contradicting viewpoints about these managers impeding the flow of the process of data fiduciaries providing consent artifacts and sending evidence of consent recordings to regulators and auditors were also raised. To watch the entire video on the conference, please refer to the link in the description box. Concerning the obligations of data fiduciaries, several mechanisms need to be followed. First, the notices issued by data fiduciaries to individuals for obtaining the latter's consent must be clear, self-contained, and easily understandable. Additionally, the notice must also provide an itemized list of the personal data collected and the purposes for their processing, alongside links for users to withdraw consent from such processing. This provision is significant, given previous concerns about data being misused for different purposes by any individual or entity once the consent is obtained for processing. Additionally, fiduciaries must also ensure the security of personal data by implementing various reasonable security measures like encryption, obfuscation, masking, or using virtual tokens linked to data, among other measures to be undertaken. Moving on to significant data fiduciaries, the Act states that the central government can label certain entities depending on the factors like the amount and sensitivity of personal data they handle, potential risk to individuals' rights, impacts on India's sovereignty and security, among others. As per the rules, the significant data fiduciaries must ensure that they process personal data based on recommendations of a committee with restrictions that the personal data and traffic data pertaining to its flow must not transfer outside India. These fiduciaries must also conduct data protection impact assessments and audits every 12 months from its inclusion date as a significant data fiduciary. This later must be submitted to a data protection board in the form of a report detailing the key findings. Significant data fiduciaries must also appoint a data protection officer to handle grievance redressal, among other duties. Finally, every data fiduciary must display on their website the contact information of data protection officers or any other person who can answer queries about how they process personal data. Besides the previously mentioned obligations, data fiduciaries must also undertake several steps in case of a data breach, not fulfilling which could attract fines of up to rupees 250 crore. To prevent such breaches, companies must implement several security safeguards, like having visibility on who is accessing the personal data through appropriate logs, monitoring, review, and so on. Companies with contracts with data processors or entities who process the data on behalf of the data fiduciaries must also ensure that their processors implement reasonable security safeguards during processing activities. In case of occurrence of a potential data breach, fiduciaries must inform the affected individuals immediately and in a clear, concise, and plain manner. This communication may be facilitated through the person's account or through any other communication mechanism that they have registered with the company. Details like description of the breach, its potential consequences, mitigation measures by the company, and the business contact information of any company employee to respond to queries about a breach must be included in such an intimation. In addition to the affected user, the Data Protection Board must also be informed about such breaches without any delay. The rules mandate that companies must provide details like updated description of the breach, any findings on the perpetrator of the breach, and remedial measures to prevent its reoccurrence alongside others within a period of 72 hours. An extension for the period may be provided in case fiduciaries submit a written request for the same. The clarification on the time period acts on previous concerns about the lack of specific timelines to report data breaches. However, questions still remain about the adequacy of a 72-hour period in terms of the companies having information about measures taken to tackle the breach within the time span. To explain, in cases of ransomware attacks, companies are typically locked out of their systems for extended periods of time, and this could hinder their ability to furnish specific information pertaining to the breach. Additionally, issues like disproportionate penalties and overlap of these rules with other regulations have also been called out previously. To explain the first, since the DPDP Act applies equally large fines for failing to prevent or report on personal data breaches to both large and small companies, experts have suggested that the penalty should be decided by the Data Protection Board based on factors like the size of the company and the extent of the harm caused instead. Concerning the second point, while the board directs companies on how to clean up data breaches, a separate government entity, namely the Computer Emergency Response Team, or CERT-IN, also released guidelines on reporting cybersecurity incidents which could lead to jurisdictional overlap. When asked about how companies are supposed to navigate this, the former Minister of State for IT, Rajiv Chandrasekhar, said that data breaches will have to be reported by companies to both the CERT-IN and the Data Protection Board of India. Speaking of the Data Protection Board, this entity seeks to act as India's privacy enforcement authority, balancing the rights of data principals and the responsibilities of data fiduciaries. In terms of its constitution, the board would comprise the chairperson and other members selected through a due process. A search cum selection committee chaired by the cabinet secretary will identify individuals with expertise in law, technology, or public administration, and finalize appointments for the board would be made after considering the candidates' professional credibility, among other qualities. As discussed previously, the board would handle complaints about data breaches, ensure compliance with data protection obligation, and monitor fiduciaries for compliance with established standards. If a fiduciary fails to comply, the board will have the authority to issue directives, suspend operations, or revoke registrations. However, if individuals are dissatisfied with the board's decisions, they can file appeals with the appellate tribunal following the due process outlined on the tribunal's website. The rules also shed light on several powers of the central government. Firstly, it outlines the procedure for the government to process the personal data in issuing subsidies, licenses, or other services to data principals. This can be done under the following circumstances. Number one, if the user has previously consented to receiving the aforementioned benefits. Number two, if pre-existing records are available in any database, register, book, or document by the government or any of its agencies. And number three, if the government is issuing such a subsidy or service under a law, policy, or using public funds. However, standards like lawful processing, retaining personal data only to achieve specific purposes, and ensuring the accuracy of such data needs to be adhered in the following processes. The rules also clarify how central government can call for information from data fiduciaries or intermediaries as listed under Section 36 of the DPDP Act 2023. However, information can only be called for specific purposes affecting the sovereignty and integrity of India, the security of the state, and in performing any duty under law or an assessment for notifying an entity as the data fiduciary. This information must be furnished within a specific time frame and through the authorized personnel dedicated for each purpose. In case of a disclosure that would prejudicially affect the sovereignty and integrity of the country or the security of the state, the data fiduciary must refrain from providing the information without first obtaining the written permission from the authorized person. However, this power of the government has invited scrutiny from experts on several fronts. Purposes like sovereignty and integrity of India and security of the state, which remain undefined in the context of the draft rules, could be used to target entities critical of the government. Further, since there exists no process for an appellate mechanism against such calls for information by the government, data fiduciaries and data principals would have no choice but to prevent itself from excessive data collection requests. Overall, the compliance would also increase burdens on data fiduciaries through such requests. Speaking of other government powers concerning cross border data transfers and data localizations, the rules stipulate that data fiduciaries must meet specific requirements set forth by the central government before transferring data to other countries. These requirements can be issued through general or special orders by the government. Further, significant data fiduciaries should ensure that the personal data specified by the Indian central government is not transferred outside the country alongside the traffic data pertaining to its flow. However, this rule varies from the Act itself, which allowed cross border data transfers except to countries specifically restricted by the government. In its 2022 draft, the government had allowed personal data transfers to countries notified by the government, with some interpreted as personal data localization in India by default. The government reportedly began considering a current approach earlier this year following industry feedback. Its past approach was expected to increase compliance costs for foreign and Indian businesses, virtually stalling businesses and startups dependent on global data transfers to keep their operations running. Notably, as per MediaNama's analysis, this new rule conflicts with the USA's Reforming Intelligence and Securing America Act, or RISA, which compels US-based enterprises to share the data of foreign citizens with American agencies. Moving on to entities that are exempt from the provisions of the Act, those processing personal data for research, archival, statistical purposes are exempt, provided there are adequate security safeguards to prevent breaches of personal data. Besides this, several others, like standards like lawful processing and ensuring accountability of the person who determines the purpose and means of processing data, among others, also need to be maintained. These standards also extend to the processing of personal data by the states and its instrumentalities for the issuance of any subsidy, benefit, service, certificate, etc. Further, central government can issue a notification exempting any instrumentality of the state from the Act's provision in the interest of the sovereignty and integrity of India, maintenance of public order, friendly relations with foreign states, and so forth. This provision has been met with severe criticism from lawyers and experts. Among the few, Justice B.N. Srikrishna, the chief architect of the 2018 iteration of the privacy law, previously remarked, "Now every babu, bureaucrat, will say, I need access to your data in the interest of the sovereignty of the nation." Taking these critiques into view, the former Minister of State for IT, Rajiv Chandrasekhar, assured citizens of internal checks and balances to prevent the misuse of such provisions. However, this clarification was still debated by many. Notably, the state and its instrumentalities, which retain personal data for an unlimited period of time, regardless of whether the purpose for which it was collected was served or not. Further, users don't have the right to request the government or its instrumentalities to erase the data. Besides these entities, startups and law enforcement agencies among others, have also been exempt from several provisions of the Act. Overall, while the rules fill up a lot of gaps that the DPDP Act 2023 left behind, there is still a lot that they don't specify. For instance, while the government has listed the factors in consideration to denote a significant data fiduciary, there is still no notification on which companies will fall within the scope of this category. Likewise, the rules don't specify the companies or startups which will be exempt from the Act's provisions or the threshold of the companies that they will have to fall into to meet the scope of this exemption. Moreover, the rules in the Act also lacks explicit mention of sensitive personal data, which last found mentions in the 2019 version of the Data Protection Act, which was then a bill. The same is a point of concern for categories like health data as well, which lacks regulatory protections. In the bill's 2019 version, journalists also had data processing exemptions, a provision now missing from the 2023 legislation or the 2025 rules. This remains important as bodies like the Editors Guild of India have previously pointed out that journalistic coverage of entities in the public interest may conflict with the right to protection of personal data. Finally, while the Act vests the Data Protection Board with the same powers as a civil court in matters summoning and enforcing the attendance of any person, examining her on oath, or other aspects where the government can prescribe a similar power to the board have not been listed in the recently released rules. Besides these absences, the draft DPDP Rules 2025 have also led to confusion about whether or not all users will have to verify the age and identity to access online services. While some argue that companies will use self declaration measures to determine whether the person signing up is a child or not, others believe that the platform will have to verify everyone's age. Another issue is that of consent provisions causing user drop offs, especially among lower income and rural households where getting synchronous consent, that is, right before a child uses a platform, is extremely difficult. Additionally, in terms of the lack of clarity on data localization, compliance with existing cross border initiatives could become an issue. To explain, Monica D'Souza, the ambassador for Emerging Payments Association of Asia, explained to MediaNama previously that while her company has ongoing trade agreements and cross-border payment initiatives, there is no clarity on the impact of the privacy law, which mandates the erasure of data on physical and digital trade because both require data to be shared. She added that while there is a provision about jurisdictions, the lack of clarity could reduce compliance with existing initiatives. That's all for now. Thank you for watching. For more tech policy updates, please subscribe to MediaNama.